My Lords, I'm grateful to the Noble Baroness Lady Chakrabarty for mentioning the release test, which is the subject of Amendment 161 standing in my name. But before I come to speak to it, may I just say a word of sympathy and support to my noble and learned friend, the Minister, who probably feels a little bit sort of under pressure today. I hope that isn't how he feels, because we are actually all on the same side on this, and we recognise very much the compassion and seriousness and commitment that my noble and learned friend, the Minister, has brought to this subject during his time serving in His Majesty's government. Amendment 161 stands in my name, and it's also supported by the noble Lord Blunkett, the noble Baroness Lady Chakrabarty, and the noble and learned Lord Hope of Craighead. It also has the support, I might say, of the Bar Council, the Independent Advisory Panel on Deaths in Custody, and others. And although it stands in my name, it is not actually my amendment. This amendment was drafted by the late and much lamented Lord Brown of Eton under Heywood, who, of course, as many of us recall, all of us recall, burnt with a passion on this topic and felt it very, very strongly. And we miss him very much in this debate these debates we're having today. Briefly summarised, the effect of the amendment would be to change the burden of proof in the Parole Board's release test, specifically for IPP prisoners. The current test is as set out in Section 28 of the Crimes, Sentences and Courts Act 1997 as amended, and it is that the Board must not direct the release of the prisoner unless the Board is satisfied that it is no longer necessary for the protection of the public that the prisoner should be confined. In effect, the prisoner has to satisfy the Parole Board that he or she is no longer a threat to the public. This is a very high test and a high bar. The amendment would change that so that and create an assumption that the prisoner will be released unless the Parole Board is satisfied that it remains necessary and proportionate for the protection of the public that the prisoner should continue to be confined. This is a subtle shift. In fact, one of the objections I have heard to this amendment from advocates for IPPs is that it is not going to change things enough, that in practice the Parole Board will continue to apply tests of practical judgment to the question, but I think it will have an effect, even if it's a small effect. The noble Baroness used the word nudge, in nudging the Parole Board in a certain direction by making it clear to them what the will of Parliament is in relation to these prisoners in particular, in the special circumstances that obtain. A question has also been raised, which I'll deal with now, about the relevance of the word proportionate, which the late Lord Brown introduced into the amendment. Necessary and proportionate. What does that mean? Does that not include an element of vagueness that might somehow pollute the effect of the amendment? I don't think so, my Lords. I think the word proportionate is meant to convey to the Parole Board that they should look at other means of assuring the safety of the public other than confinement in prison when they come to consider these cases. And that might include enhanced supervision in the community by way of tags or other sorts of devices, quite commonly used, that help to ensure that a released prisoner on licence remains broadly safe and not a threat to the public.
My recollection is that in the original 2012 legislation, there is in fact a clause that would shift the burden of proof in the way he describes. I remember the difficulty I was having in persuading my then Prime Minister to enable me to put the abolition of IPPs into the legislation at all. and I had to settle with him that we would put this into the legislation, but not for the time being enact the change in the burden of proof. Couldn't what he's seeking to achieve be now delivered by the straightforward provision of bringing that long dormant 1912 clause into effect?
I'm somewhat crushed by the fact that the noble and learned Lord is able to bring before your Lordship's House a point that he recalls after 14 years simply from memory, but which I had to spend a large part of this afternoon looking up so that I could get the wording correct, and which I was about imminently to turn to, because I was about to say that this amendment is not, in fact, in any sense radical, because it simply builds on a power that the Secretary of State already has and makes it a duty. My noble and learned friend is referring, and I'm sure he recalls this better than I do, to section 128 of the Legal Aid, Sentencing and Punishment of Offenders Act of 2012, which was indeed his legislation. And that section does give the Secretary of State the power, by statutory instrument, to amend the Parole Board's release test for IPP prisoners, not excluding the manner in which this amendment would oblige the Secretary of State or oblige the government to change the current provisions. So, as my noble and learned friend says...
The noble Lord, give way very briefly. I heard what the noble Lord Clark had to say, and I know that if my noble friend Lord McNally were in his place, he would say that when he, as a junior minister, and the noble Lord Clark were at the Department of Justice, they were of the view that it would be a matter of a short time only that Section 128 would be implemented. And it was a matter of great disappointment to my noble friend that it has taken until now, and indeed not yet, for that section to be implemented, reversing the burden of proof.
I'm very grateful that, again, my speech is being shredded in advance by points that I was about to make. Really, we are making this extremely easy for my noble and learned friend, the Minister, to agree with us. What we can all agree on as a matter of fact, that Section 128 of LASPO has not, in fact, been implemented 14 years on. And it is for that reason that this amendment is being brought forward, so as to leave the government with no choice in the matter, but to oblige them, in effect, to deal with IPP prisoners in the manner that my noble and learned friend has indicated was always the hope and the intention. And in fact, I was going to, at this point, make a reference to a remark made by my noble and learned friend, Lord Clark, at an earlier stage when we were discussing IPP prisoners, when he had in fact said that nobody at the time, in 2012, believed that there would still be IPP prisoners in confinement 14 years later. And so it is this point that I'm trying to address. So very, very simply, I simply want to say that this is a very small shift in a power that already exists for the government. It is therefore, in effect, a very modest amendment, and therefore one that I hope both my noble and learned friend, the Minister, and indeed the opposition front bench would feel able to support.
Lords, I should like